Good evening, everyone. I'm Kritika Goyal, and it's my privilege to welcome you all to the Judicial Services Exam Preparation Lecture Series on Electronic Evidence organized by LiveLaw Academy. Today, we are honored to have with us Justice K. Abraham Mathew, former judge of Kerala High Court. Good evening, sir. Thank you so much for gracing us with your presence. Before we begin, please allow me to briefly introduce sir. Justice K. Abraham Mathew is former judge of High Court of Kerala. Sir has also been the former director of Kerala Judicial Academy. It is also my pleasure to announce that LiveLaw Academy is launching its Judicial Services Preparation course, and that Justice Abraham Mathew sir has kindly agreed to take some major subjects like BSA and BNSS. We are deeply honored to have you with us today, sir. Thank you once again for joining us. With that, I now hand over the stage to you, sir.
Thank you, Madam Kritika Goyal. So, our topic for today is electronic evidence. Hello? Hello?
Yes, sir. Yes, sir.
I can continue, I think.
Yes, sir. Please continue.
Yes.
Thank you.
So, when we come to the topic electronic evidence, the first question we have to ask ourselves is, how many classes of evidence are there under the BSA or the Indian Evidence Act? Ordinarily, our students of law will say that there are only two types of evidence: oral evidence and documentary evidence, because the definition of evidence in the Indian Evidence Act as well as BSA mention only these two classes of evidence. But suppose a weapon is produced in a case, weapon like a knife. What type of evidence is this? It neither comes under this oral evidence or documentary evidence. Then what type of evidence, what class it belongs to? It belongs to a third category called material evidence. Though you do not find the term material evidence in this BSA or Indian Evidence Act, the Supreme Court has recognized that there is a third class called material evidence. That is in Kathikalu versus the State of Bombay, AR 61 Supreme Court 1808. So material objects come under this class, material evidence. That class also is known as real evidence, physical evidence, or demonstrative evidence. You can find mention of these material objects in the second proviso to section 60 Indian Evidence Act, and in section 165, which corresponds to section 168 BSA. The court has the power to order any person to produce a thing. So a material object is a thing other than a document. Now the next question is there any class of evidence called electronic evidence? Will you find this term in the BSA or in the Indian Evidence Act? So in section 39, that is the former Indian Evidence Act is the section 45A, it has used this term, section 39(2). That is the older section is section 45A. It mentions electronic evidence. When in any proceeding, the court has to form an opinion on any matter relating to any information that electronic records. The opinion of the examiner of electronic evidence referred to in section 79A of the Information Technology Act is a relevant fact. So the term electronic evidence is used not only in this BSA, but in Information Technology Act also. So there is a fourth class of evidence called electronic evidence. It is recognized by the statutes also. So what does the section 39 say? Section 39 says that electronic evidence given by an examiner of electronic evidence appointed under Section 79A of the Information Technology Act. It is relevant. It is relevant. And that person is called an expert in electronic evidence. But what is missing there? Something is missing in Section 39 of the BSA. What is missing there is, it only says that the opinion of the examiner of electronic evidence is relevant and such person is an expert. But it does not say that without his examination, the opinion given by him is admissible. It only says that it is relevant. It necessarily follows that it is necessary to examine the examiner of electronic evidence, to prove his opinion. It is not a statutorily declared evidence like sections 292 and 293 CRPC. Sections 292 and 293 CRPC declare reports of certain persons like officers of Mint as forensic science laboratory experts as evidence, and is not necessary to examine the maker of the report. So it is necessary to examine to prove the opinion given by an electronic examiner electronic evidence, to prove his report or the opinion. That is what we have to take notice of with regard to Section 39, subsection 2. We have to take notice of Section 2, subsection 2 of the Bharatiya Sakshya Adhiniyam. Words and expressions used herein, but not defined in this BSA, but defined in Information Technology Act or the BNSS or BNS, will have the same meaning as assigned to them in those statutes. So we can see that there are some terms used, there are some words, terms and expressions used in the BSA which are not defined in this act, but they are defined in Information Technology Act. For example, take the case of electronic record. The word electronic record is not defined in the BSA. Data is not defined in the BSA. Computer is not defined in the BSA. Computer system, computer network. These are all terms used in the BSA, but they are not defined in the BSA, but they are defined in the Information Technology Act, Section 2. Section 2. So BSA has borrowed, or it borrows, many terms from the Information Technology Act. So what is the nature of BSA? That is Bharatiya Sakshya Adhiniyam. It's a direct translation of the Indian Evidence Act. Adhiniyam only means an act, a statute, nothing more. So when we come to the nature of BSA or the Indian Evidence Act, it is said to be procedural, mostly procedural or adjective. So there is a rule of interpretation. So far as a procedural law is concerned, what is the law? The ordinary law is that a procedural law, when enacted, will have retrospective effects. It means that it applies not only to the proceedings instituted thereafter, but to the proceedings pending as on the date on which it comes into force. It means that it is retrospective in nature. The rules of evidence in BSA, ordinarily, when the ordinary rule is applied, should apply to pending proceedings also. But the legislature is competent to make a provision to the contrary. There is no bar. So the central government or the parliament has made a law which is not consistent with the ordinary rule. You can find it in section 170, subsection 2. Section 170, subsection 2 of the BSA says that notwithstanding the repeal of the Indian Evidence Act, the provisions in the Indian Evidence Act will apply to pending proceedings. That means pending proceedings. There is application trial. This adhiniyam comes into force. There is any application, trial, inquiry, investigation, or other appeal pending there, then the provisions in the Indian Evidence Act will apply and not the provisions in the BSA. That means it is retrospective in nature, not only retrospective, to some extent prospective also. So which will apply to a pending proceedings? Indian Evidence Act will apply and not BSA. But there is also something to be borne in mind when we say that it is Indian Evidence Act, provisions of Indian Evidence Act that will apply so far as the pending proceedings are concerned. It says that the provisions of the Indian Evidence Act will apply at different stages. So different stages are mentioned in subsection 2 of section 170. For example, investigation, the stages mentioned here are: 1, investigation, the inquiry, trial, application, proceedings, appeal. These are different stages of a case, a litigation. So what does it mean? It simply means this: the applicability of the Indian Evidence Act or the BSA will depend upon the stage at which the question arises. So it may apply, Indian Evidence Act will apply to some stage and BSA will apply to another stage. So these two acts will apply to the same case at different stages. That's what subsection 2 of section 170 says. So we shall consider how can we decide which act will apply to a proceedings pending before a court. So we know that so far as a civil case is concerned, mainly there are only 2 stages. One is trial, the other is proceedings before the trial. And the trial starts with framing of issues. So far as civil law is concerned, there may not be much problem. But so far as the criminal law is concerned, there are 3 stages, well recognized 3 stages ordinarily in a criminal case. The first is investigation, the second is inquiry, and the third is trial. For the time being, you forget application and appeal. So how can we decide which act will apply? Take the case of investigation. Investigation is nothing but it is defined. It is all proceedings for the collection of evidence. And ordinarily, it is in the realm of police. Investigation is in the realm of police and magistrate has nothing to do with investigation. So the question here is there any application of rule of evidence during investigation? The answer is no. In investigation, it is conducted by the police and there is no question of any provision in the Indian Evidence Act or the BSA being applied. But when we come to the inquiry, inquiry commences where the investigation ends. Investigation is done by the police, but inquiry is always done by the magistrate. So inquiry starts where the investigation ends. Inquiry is also defined in BNSS. It is all proceedings before a magistrate except the trial. So inquiry is a stage between investigation and trial. Inquiry always takes place before a magistrate. So the question here is there any occasion for a magistrate to apply rule of evidence in an inquiry? there are different types of inquiry under the BNSS. The first one is inquiry under Section 225 BSA or Section 202 Indian Evidence Act. That inquiry in a complaint case. When a complaint is instituted and the magistrate takes cognizance of the offense, a magistrate has to conduct or he may conduct an inquiry under subsection 2. And that inquiry also is a proceedings before a magistrate. It's a judicial proceedings before a magistrate. So sometimes the question of applicability of the provisions in the BSA may arise. The second inquiry we can see, inquiry under section 267. That is now, so the old section in the old act, that is Indian Evidence Act, is 244. That inquiry is called pre-trial inquiry in a warrant case instituted on a complaint. The purpose of that inquiry is to ascertain whether there is a sufficient ground to proceed with the case. And there, witnesses are examined. And now the Supreme Court has said that the defense has a right of cross-examination, even during that stage. So certainly, the question of applicability of the provisions in the BSA will arise for consideration because the magistrate records evidence during inquiry under section 267 BSA. The third stage in a criminal case is a trial. So we have seen that the term investigation is defined, the term inquiry is defined in BNSS or the CRPC, we may say, but the word trial is not defined. And this has given rise to some controversy. What do you mean by trial? When does a trial start? The word trial is used in two senses. One is very broad. The sense in which it is used in a broad sense is that it commences with the courts taking cognizance and not with the examination of witnesses. But the narrow sense in which it is used is trial starts with the framing of charge. Here, in section 170, subsection 2, BSA, the word trial is used in the narrow sense. Otherwise, it becomes illogical. So trial means trial, the proceedings starting with the framing of charge for the purpose of section 170, subsection 2. Now, another proceedings is appeal. There cannot be any dispute with regard to the appeal because an appeal comes into existence when an appeal memorandum is instituted, duly instituted. There cannot be dispute regarding it. So another term which is used is application. In section 170, subsection 2, the word application is used. What is the sense in which it is used in section 170? The sense in which it is used in section 170, subsection 2 is this: it should not be an interlocutory application. Because even during the trial or inquiry, interlocutory applications may be filed. So application here means applications other than interlocutory in nature. Another stage that finds mention in section 170 is proceedings. What do you mean by proceedings? In civil cases, we can say any proceedings under the CPC other than a trial is a proceedings before a civil court. But what about the criminal case? In criminal case, we have seen that there are three well-defined stages. One is investigation, which is defined. The other is inquiry, which is defined. The third is a trial, which we can say starts with the framing of charge. Is there any proceedings other than these proceedings? Yes, there are proceedings other than inquiry or trial before a magistrate. Take the case of tendering pardon to an approver. That is old section 306(4), 306 Criminal Procedure Code. Now it is section 343. When a magistrate tenders pardon to an accused, after the offer is accepted by the accused, the magistrate has to examine the approver who has accepted the tender of pardon. Here, what is the nature of the proceedings? A question arose whether the accused has a right of cross-examination. At that stage, that is section 306, subsection 4, the Supreme Court said that the accused has no right of cross-examination, though the word used is witness and the other word used is evidence. He has no right of cross-examination because it is neither inquiry nor trial. So it is a proceedings which do not amount to inquiry or trial, but it takes place before a magistrate. You can note down AIR 2000 Supreme Court 908. It is a proceedings before a magistrate, but it does not amount to inquiry or trial. So there are proceedings before a magistrate in a criminal case other than inquiry and trial. The magistrate merely records the proceeding, the statement of a witness. So we have seen that Indian Evidence Act or the BSA will apply in different stages of the same case. How can we decide the provisions of which act will apply? Which act will apply? The first question before us is this: what is the stage at which this question arises for our consideration? What is the present stage of the proceedings? Is it an investigation? Is it an inquiry? Is it a trial? Is it a proceedings other than these two? So once you identify the stage at which this question arises, the second question arises. The second question is, when did this proceedings which is pending before you at the present moment, commence? If it commenced before 1/7/2024, it means the provisions of Indian Evidence Act will apply and not BSA. That means it is prospective. So you have to identify the stage at which this question arises and decide whether it was pending as on 1/7/2024 or not. If it was pending as on 1/7/2024, to that stage, the provisions in the Indian Evidence Act will apply and not the provisions in the new act. So you have to ask two questions. One, what is the stage at which this question arises? The second, when did it commence? Before or on or after 1/7/2024? These answers will give you the answer to the question, which act will apply. Okay. So illustration, as an illustration, we can take a case where the investigation was completed before 1/7/2024. The police report was filed on 1/7/2024. So the question is whether the provisions of which act will apply to the inquiry, which is the present proceedings before you, stage before you. The answer is obvious. It commenced after 30/6/2024. That is on and after 1/7/2024. That means the new act will apply. Suppose police report was filed before 1/7/2024 and the magistrate took it, or the court took it on file before 1/7/2024. Inquiry already started. So the provisions of which act will apply? since it's commenced before 1/7/2024, the inquiry commenced before 1/7/2024, the provisions of Indian Evidence Act will apply. And that inquiry was completed after the coming into force of the BSA. So to the next stage, that is the trial, BSA will apply. So far as a single case is concerned, at different stages, the provisions of Indian Evidence Act or the BSA will apply according to the stage at which this question arises. This is actually the difficulty that may arise in answering this question. And suppose instead of saying that it applies to different stages of the same proceedings, the provision actually provided that the provisions of BSA will apply to the proceedings instituted before 1/7/2024. There would be no difficulty because one case is considered a single proceedings. But here, even one case is considered as different stages, identified stages, so that Indian Evidence Act may apply and BSA will apply to different stages. So these are the questions we have to ask ourselves before getting the answer. The provisions of which act will apply, Indian Evidence Act or BSA. So the illustrations will make it clear for you. Now we come to the definitions. So we have seen that Section 170 is an exception to the ordinary rule that a new act will be retrospective. It is prospective in one sense and retrospective in another sense. It is both retrospective and prospective, depending upon the stage at which this question arises for consideration before the court. Now we come to one of the definitions in Section 2. We know that in the Indian Evidence Act, the definitions of the words and terms contained in sections 3 and 4. Now they have been clubbed and all the definitions have been brought under one section, that is Section 2. Section 2 can be said to be the dictionary of BSA. It is the dictionary of BSA. But one section stands out, one subsection stands out. Subsection 2 or Section 2, we have already seen words and expressions used herein and not defined but defined in the IT Act, BNSS or BNS will have the same meaning as are assigned to them in those statutes we have already seen. So with this introduction, we shall start the discussion of various provisions in the BSA so far as electronic evidence is concerned. We have seen Section 39, which uses the term electronic evidence, and the provision Section 79A in the Information Technology Act. So let us start with the definition of the word document. In the Indian Evidence Act, the definition of document did not include electronic records. So there was a dispute whether an electronic record is a document or not. Now that has been clarified. Section 2D of the BSA defines the document. And apart from the definition of the document which was seen in the Indian Evidence Act, something more is added there. Something more is added to the definition which we could see in the Indian Evidence Act. That means documents include electronic and digital records. So an electronic record or a digital record is a document now. Immediately I have to mention that there is no term as electronic documents. The term electronic document is not used anywhere. Information Technology Act or the BSA or BNSS or BNS. It is only electronic record. And electronic record is defined in Information Technology Act. But we have seen that subsection 2 says if the meaning of an expression used in the BSA is not given in the BSA, but given in BNSS or BSA or Information Technology Act, it will have the same meaning as assigned to them in those acts. So here we have seen two terms, electronic records and digital records. In the definition of the term document, electronic records is defined in section 2T of the Information Technology Act, but it is not, the term digital record is not defined. Digital record is not defined in BSA, nor in Information Technology Act, nor in BNSS, nor in BNS. So what is the meaning of the word term digital record? Digital record, to my knowledge in this electronic records is very limited. I belong to the old generation. We can say, what I understand from those who are in the know of things is that a digital record means there was already a record in physical form, just like a paper, just like a book, and it was converted into electronic form. And that converted electronic form is called digital record. So there was a physical form, document in a physical form, and it's converted into a digital electronic form. Then it becomes a digital record. This expression is used in the other provisions in the Indian BSA. So we have to understand the meaning of the word digital record. So digital record and electronic records, both are documents. Both are documents under the BSA. It was not so in the Indian Evidence Act. That's a change that has been brought in by BSA. In the definition of the word document, section 2D. And now we have to read section 61. Section 61. BSA. Section 61 is a new provision in the BSA. There was no corresponding provision in the Indian Evidence Act. Section 61. This section 61 says that an electronic or digital record is admissible as just like a document. It is just like a document, merely because it is an electronic record. It cannot be said that it is not admissible in evidence. What is the difference between an electronic record and a document other than electronic record? We know that under the definition of the Indian Evidence Act, a document should have two things. Unless there are two things, there was no question of a document. One is a substance. The other is a content. In other words, document means a matter expressed or described upon a substance. So two things constitute a document. One, a substance. The other, a matter expressed upon it. That is the contents of the document. But substance means something which has a physical form, like a paper, like a tree, like an object, anything like that. Anything like that. But so far as an electronic record is concerned, it is not in tangible form. So merely because it has no tangible form, we cannot say that an electronic record is not a document. That's what section 61 says. Merely because a record is an electronic record or a digital record, one cannot say that it is not admissible as an evidence in the case. It is still admissible. So section 61 declares admissibility of electronic record just like a document. It further says, what does it further say? Section 61. It further says that once it is proved, it will it will have the same effect of proving a document. So what is the effect of proving a document? An electronic record, if proved, will have the same effect. That means all electronic records and digital records and documents other than electronic or digital records stand on the same footing so far as admissibility and the effect of admissibility are concerned. That is what section 61 says. It is a new insertion in the BSA, which you cannot see in the Indian Evidence Act. There is no corresponding provision. Now, coming to the documents. A document, how can you prove a document? How can you prove a document? The first question is, what should be produced? What should be produced to prove the contents of a document? The answer you get in section 64, the old section 64, which is corresponding to section 59 it is now. Sometimes I may be confused because of this provision. Yes, we can see section 61, that is section 59 now. Documents shall be proved by primary evidence. 59, corresponding to section 64 now. Documents shall be proved by primary evidence. Actually, what it means is that what should be produced to prove the contents of a document? You should prove the primary evidence. Ordinary rule is production of or proof of contents of a document by primary evidence. Exception is a secondary evidence. So, a document has primary evidence as well as a secondary evidence. Primary evidence means the document itself. So whenever you see the word document in the Indian Evidence Act or BSA, you have to add one prefix a word, original document. Only an original document is called a document by BSA or Indian Evidence Act. A copy is not called a document. A copy is only an evidence of a document. So you can either produce the primary evidence or the secondary evidence of a document, provided it is permitted by the Act. So far as electronic record is concerned, is there primary evidence and secondary evidence? Are they admissible? Just like a document, an electronic record also may be proved by primary evidence or secondary evidence. Both are there. Both are there. So the ordinary rule is proving the contents of an electronic record by producing and proving the original electronic record. So it is necessary to decide whether the record that is produced before the court is an original electronic record or a secondary evidence. Where can we see it? Whether it is an original record or it is not an original record. And secondary evidence. You see section 57. Section 67. The old section was section 62. Corresponding provision is primary evidence, section 57 in the BSA. It defines primary evidence. Primary evidence means the document itself. That is the original document. So only original document is called primary evidence. An explanation is given. There were two explanations in the Indian Evidence Act to section 62. But under the BSA, a change has been effected. The two explanations have been now split up into three. So the two explanations which you found in section 62 are now explanations 1 to 3 in BSA. There is no other change. And explanations 1 to 3, they relate to ordinary documents, documents other than electronic records or digital records. But explanations 4 to 7, They are new provisions. They relate to electronic records alone or digital records. Explanations of 4 to 7 apply only to electronic records. And they say what type of record is a primary evidence in the cases of electronic evidence, electronic records. Explanation 4. Where an electronic or digital record is created or stored, and such storage occurs simultaneously, sequentially, in multiple files, each such file is primary evidence. What does it mean? It applies to both electronic and digital records. It applies to a record is created. Created. You will find this word create in old section 65B, now section 63. It has a significance. What do you mean by create? An electronic record is created. But when we said a document is created, it has a negative connotation. It means you are fabricating a document. You are fabricating a document. But in the case of electronic record, the word used is created. You create an electronic record. What does it signify? What is its significance? It means it is similar to the word execution in relation to a document. When you sign a document, you say you executed a document. You execute a document when you sign it. But in the case of electronic records, except in the case of electronic signature, you do not put your signature there. But you create a document. That document is electronic record. So electronic record is creation of electronic record is just like execution of a document. When can you say that you executed a document? You execute a document only if it is an original one. You do not execute copies. You execute only an original document. So likewise, when this term is used in section 57 in BSA, that is, you create an electronic record, it means you brought into existence an electronic record for the first time. So you create an electronic record. When you bring into existence an electronic record for the first time, and if you take copies, you are not creating electronic records. You are only creating, you are only making copies of it. So the difference between creation and the other words are the difference is significant. So here the word is used where an electronic or digital record is created. So you create a document on your laptop, on your computer, on your mobile phone. You create an electronic record. Then you are stored. Then you store it. You store it. You can store it in the same device, or you can store it in different devices, several devices. And the same electronic record may be stored in different files, multiple files, in the same device or in several devices. And each of the multiple files in which it is stored is a primary evidence, But there is a condition. There is a condition. What is that condition? All this storage happened in different files, multiple files. How? Simultaneously or sequentially. What is the meaning of the word simultaneously? Simultaneously means at the same time. At the same time. And sequentially means one after another in quick succession. One after another. Suppose you make idlis. Several idlis. They are made. All these idlis come into existence simultaneously. All these idlis come into existence simultaneously, not one by one. Steam enters this particular vessel simultaneously. And all these 10, suppose there are 10 idlis, and 10 idlis come into existence simultaneously, and each one is a primary evidence of idli. You need not prove all the 10. It is sufficient you to prove one, and each idli is independent. Likewise, each file stored in a computer device becomes an independent one, and it is a primary evidence. It is sufficient for you to prove one. And sequentially means one after another. The storage takes place, the first device, the first file one, second next, third next, one after another in quick succession. That is called a sequential. So here, what is to be noted is this. There are some conditions to call a electronic record a primary evidence. The condition is that the storage took place simultaneously or sequentially. That means when the witness gives evidence, he has to testify that the storage took place simultaneously or sequentially. Then only it becomes a primary evidence. Primary evidence. That is what section 4, explanation 4 says. Then, explanation 5. Where an electronic or digital record is produced from proper custody. Produced from proper custody. Such electronic or digital record is a primary evidence unless it is disputed. So the first thing is whether the electronic record is produced from proper custody. What is proper custody is not defined for the purpose of this section. For the purpose of another section, it is defined, but not for the purpose of this section. So what do you mean by proper custody? The only requirement is the electronic record is produced from proper custody. What does it mean? It means that the person who produces it need not be the owner of it. It is sufficient that it is produced from proper custody. Suppose I have a mobile phone with me and it belongs to the department in which I serve and is given to me for my use, exclusive use. The department is the owner of it, but I am the proper custodian of it. So if I produce it, it becomes a primary evidence. So if I produce an electronic record from my proper custody, the custody of which is a proper so far as I am concerned, it is a primary evidence. So for that, the person who produces the electronic record should prove that he is the proper custodian of it. That is a requirement that is to be satisfied before it can be considered a primary evidence. But at the same time, the explanation says that unless it is disputed, that means the opposite side has the right to dispute it. Dispute what? The dispute may arise as to two things there. One, it is not produced from proper custody. The second, though it is produced from proper custody, it is not a primary evidence. Suppose mobile phone I produced, but it is challenged that I am not the proper custodian of it. It is there in the mobile phone, that electronic record. If I do not prove that I am the proper custodian of the electronic record produced, it is not a primary evidence. Likewise, the other side says that he is the proper custodian of it, but it is not a primary evidence. That also can be challenged. It can be disputed. Suppose I fail to prove that it is an original one, it was a transmitted one. Somebody transmitted it to me. That means it is not a primary evidence. So the requirement of the explanation has to be satisfied by the person who seeks to produce it as evidence in the case. Unless these conditions are satisfied, you cannot call it a primary evidence. Then, for the time being, we will skip explanation 6. We will go to explanation 7. Where an electronic or digital record is stored in multiple files, storage spaces, in a computer resource. Computer resource is defined in Information Technology Act. Each such automated storage, including temporary files, is primary evidence. So when an electronic record is stored It may be stored in temporary files or permanent files. The storage may be. Even our mobile phone has a temporary files, temporary saving is there. So here it is actually stored in storage spaces, multiple storage spaces. So there are multiple storage spaces in a single computer, or it may be in different computers. So when you save it, what is to be proved? It is not sufficient for you to prove that it is stored in multiple storage spaces, but it is necessary to prove another condition, that is the storage was automatic. So the stress is on the word automatic. Unless the storage happened automatically, explanation 7 is not attracted and it's not considered a primary evidence. So these are explanations 4, 5, and 7. Why I left out explanation 6? Explanation 6 also deals with electronic or digital records, especially electronic record, but it stands on a different footing than the other types of electronic records in explanations 4, 5, and 7. Explanation 6 deals only with a particular type of electronic records, that is video recording. So explanation 6 applies only to video recording. So it provides where a video recording is simultaneously stored in electronic form and transmitted or broadcast or transferred to another. Each of the stored recordings is a primary evidence. The classic example is live streaming. Live streaming. We know that now this ceremony is like inauguration, swearing-in ceremony of Supreme Court judges, farewell to Supreme Court judges, funeral services. These are all streamed now. There will be live streaming of these ceremonies or functions. And under the Indian Evidence Act, or before the Electronic Evidence, this provision was there for electronic records. A photo was taken by a photographer. How it could be proved? It could be proved by producing the photo as well as the negative. Not only that, you have to adduce, or you had to adduce, so you had to examine the photographer who took the photograph. That was the procedure, because the photo is a document. It's a special type of document, and you had to examine the photographer who took it, and the negative also you had to produce to ensure that it is an original one. It is a genuine one. But now that age is gone. In electronic records, video or photos, there is no negative. There is no negative. So there is no question of the acts, the statute asking a party to produce the negative. No negative is there. Then how can it be proved? Ordinarily, when a video is taken, suppose it's a video of a wedding ceremony, it is taken. How can you prove the video? Ordinary case. You have to produce the video taken by the videographer, and you have to examine the videographer. I took it. This is the original one. This is the ordinary rule. But a different rule is seen in explanation 6. In the case of live streaming. And in the case of live streaming, what happens? We know that nowadays, especially in Kerala, parents are alone at their homes. Children, educated, IT professionals, medical professionals, they go abroad and they get attractive money there, attractive remuneration. But parents are alone here, and one of the parents dies. One son is in Europe, the other is in America, another one is in Australia, and the fourth one is in New Zealand. They cannot come to Kerala. It is huge expenses they have to meet, and they will discuss the matter. It is the duty of children to give a decent burial to the father, because that is a constitutional right, fundamental right, to have a decent burial. Human right. The human right extends even beyond the death of a person. That is, he has a right to decent burial. So it is the constitutional and moral duty of the children to give him a decent burial, and they will discuss it. And the discussion ended like this. There is no purpose of our going to Kerala, because we cannot restore him to life. We cannot revive him. He will not live again, even if we go there. So what is the fun in going there? But it's our duty to give him a decent burial. For that, we can do one thing. We can engage an event management people. So event management people are engaged to do this ceremony, and the ceremony is conducted. It is videographed. Video is taken, and live streaming is there, so that the children in Europe, America, Switzerland, or wherever they are, they can see it. They watch it. And suppose a controversy arises as to this videography, and what is to be produced before the court? What is the material to be produced before court to prove that there was something wrong in this recording, this video or this event? Naturally, it will be the video. The video has to be produced, and in the ordinary case, the original video has to be produced by the videographer, and the videographer has to be examined. But explanation 6 is, where a video recording is simultaneously stored in electronic form and transmitted or broadcast or transferred to another, each of the storage recording is a primary evidence. Suppose that live streaming was recorded by one son in America, the second son in Africa, the third son in Australia, and the last one is in Europe. Each stored one will be a primary evidence. What does it mean? They need not examine the videographer. They need not get the video produced by him. It is sufficient that they produce the video that was stored by them in their computers. That is the change that has taken place in this BSI. So it should be live streaming, classic example. So where a video recordings, explanation 6 applies only to video recording, not the other forms of electronic records. Where a video recording is simultaneously stored in electronic form and transmitted, broadcast, or transferred to another, each of the stored recording is a primary evidence. So these are the explanations for primary evidence. So far as electronic records is concerned, there are 4 explanations. But the question is this: what is the significance of an electronic record being primary evidence? What is this significance? It should have some significance. Otherwise, why should we take the trouble of proving it an original electronic record primary evidence? What is the significance of something being a primary evidence, an electronic record being primary evidence? You can think about it. The significance is this: if it is a primary evidence of an electronic record, the condition of there being a certificate under section 63 or section 65B is not necessary. Is not necessary. In Arjun Pandit Rao's case, Arjun Pandit Rao, I think all of you know it, 2020 volume 7 SEC 1, 2020 volume 7 SEC 1. The Supreme Court held or reiterated that just like a document, in the case of a document, primary evidence of an electronic record also is admissible. And in the case of primary evidence, no certificate is required. Suppose you take a photo on your mobile phone and it is stored in the mobile phone. You just produce that mobile phone. That is the primary evidence. The photo is there. There need not be a certificate from anyone. But if it is a copy, is a transmitted one, transferred one, then it requires a certificate under section 63. This is the difference between a primary evidence and secondary evidence from the point of view of BSA. A primary evidence does not need a certificate, but a secondary evidence needs a certificate. But in certain cases, certain electronic records, primary evidence is impossible to produce before the court. Which are those cases? There are some situations where you cannot produce primary evidence of electronic records. They are, if it is a computer system or computer network, you cannot produce the original one. Only secondary evidence can be used. This is what the Supreme Court has said in Arjun Pandit Rao's case. That is 2020 Volume 7 SEC 1. There is no question of a party producing the primary evidence in the case of computer network or computer system. Only secondary evidences can be produced. And in the case of primary evidence, no certificate is needed. That is what the Supreme Court has held in. The first it was held in Anwar versus Bashir, that is 2014 10 SEC 473. The first important decision, so far as electronic record is concerned, is 2014 10 SEC 473. That has been upheld by the Supreme Court by another 3-judge bench in Arjun Pandit Rao's case. It held that the provisions relating to secondary evidence of electronic records is a code by itself. You cannot look into any other provision. You go only by the provisions relating to electronic records. That is a section 63. Because there was a controversy. There was a controversy. Even after the pronouncement of the decision in this Anwar versus Bashir, 2014 10 SEC 473, another bench or 2 benches of 2 judges held that it need not be, there need not be a certificate, and you can produce it under section 65 clause A. The Supreme Court said no, it's a code by itself, and unless it bears a certificate under section 65B, now section 63, a secondary evidence is not admissible of an electronic record. That is the significance of the decision of Anwar versus Bashir followed in Arjun Pandit Rao's case. So if it is a primary evidence, you need not produce a certificate as mandated in section 63, old section 65B. Now we come to secondary evidence. Secondary evidence. So just like an ordinary document, secondary evidence of an electronic document also is admissible. And section 63, old section 65B, deals with secondary evidence. The opening word is notwithstanding anything contained in this adhiniyam. That means it is a non-obstante clause. What is stated in the other provisions is not applicable to an electronic secondary evidence of an electronic record. The only section which is applicable to secondary evidence of electronic record is section 63. Section 63, old section 65B. So notwithstanding anything contained in this adhiniyam, that is a BSA. Any information contained in an electronic record, which is printed on paper or recorded or copied in optical or magnetic media or semiconductor memory, which is produced by a computer or any communication device or otherwise stored, recorded or copied in electronic form, hereinafter referred to as computer output, shall be deemed to be also a document. So what does it mean? That part, only that much we read now. What does it mean? It means that a secondary evidence of an electronic record is called a computer output. A computer output. What do you mean by a computer output? A computer output means something which has come out of a computer. Something which has been produced by the computer. Just like a baby coming out of the womb of her mother. A baby comes out of the womb of his mother. Then she is the product of that woman. Just like that. Something should come out of a computer. To call it a computer output, product of a computer. What does it mean? It implies that unless there is an original in the computer, you cannot call something a computer output. Unless there is the original is there in a computer, you cannot call some product of it a computer output. So the original is there, but it comes out in different forms. Just like a baby coming out of the womb of a mother. It may be a male, it may be a female, it may be a transgender. Just like that. Something coming out of the computer may take different forms. It may be a printout. Ordinarily, we can see printout when we buy something from a shop. We get printouts. A printout. It may be a CD. It may be a memory card. It may be in the form of a pen drive. It may be in the form of a DVD. So it may take different forms. And all these together are called computer outputs. Computer outputs. And does the section say that a computer output is a deemed document? The section does not say that. A computer output is a deemed document. To make it a deemed document, some conditions are to be satisfied. That's what the section says. If it shall be deemed also a document, if the conditions mentioned in this section are satisfied. So there are some conditions mentioned in this section as to electronic records, as to a computer output. Only if those conditions are satisfied, the computer output can be called a deemed document. It becomes a deemed document. What do you mean by a deemed document? Deemed document means really it is not a document, but it's a fiction. Deeming provision is there to create a fiction. The fiction is that it is a document because only an original is called a document. A copy is not called a document. So here the original is a document. The secondary evidence also is a document. An exceptional case. A secondary evidence of an electronic record becomes a document. It becomes a deemed document, provided it is a computer output and the conditions mentioned in this section are satisfied. The conditions relate to two things. The conditions mentioned in this section, section 63, subsections are there. They are related to two things. One, the section itself says, in relation to the information, and the computer in question. So the conditions mentioned in subsection 63, subsections 2, 3, 4, they are related to two things. One is the information contained in the computer. The second is the particulars of the computer. So two categories of conditions are there. So if they are satisfied, they are deemed to be, the computer outputs are deemed documents. So it creates a deeming provision. Because of the deeming provision and definition of section 2D, here is a rare provision. An original electronic record also is a document. A copy also is a document. A copy or a secondary evidence also is a document because of the fiction created by section 63. Okay. And if those conditions are satisfied, it is admissible just like any other document. Just like any other document. So it is just like producing the original itself. It dispenses with the production of the original. A fact therein of which, so the contents can be proved by producing the secondary evidence of an electronic record, provided the conditions are satisfied. Here we have to remember a word has been, a particular word or two words have been inserted, which you could not find in Section 65B Evidence Act, Section 65B1. Which is that one? Which is that expression? That expression was not there in subsection 1 of Section 65B of Indian Evidence Act. That is communication device. See, it says that any information contained in an electronic record which is printed on a paper, recorded or copied in optical or magnetic media or semiconductor memory, which is produced by a computer or computer device. Earlier, there was only the one expression, computer. Now, computer device also is inserted. Computer device. Oh, sorry, communication device. Communication device. And this phrase you can see in subsection 2. Computer or communication device. In subsection 3 also you see the word computer or communication device. So the expression communication device is inserted in this section 63 by BSA. That expression was not there in the Indian Evidence Act. That's a new insertion. Okay. So here, computer communication device, that term is defined in IT Act. IT Act. And you know that recently there was some incident relating to a communication device. What is that? What is that communication device? Pager. Pager exploded in Iran. It's a communication device only. So that also has now been included in it. It was not there in Section 65B. So if conditions relating to the information stored in a computer and the particulars of the computer which was used, then a computer output becomes a secondary evidence. That is, it becomes a deemed document and it becomes admissible in evidence. So unless these two conditions are satisfied, the conditions are satisfied, it does not become a deemed document. It will continue to be a computer output, but not a deemed document. So all deemed documents under Section 63 are computer outputs, but all computer outputs are not deemed documents. Only those computer outputs which satisfy the requirements of Section 63, conditions of Section 63, are deemed documents. And do you know whether there are any other deeming provisions in the BSA? There's nothing to do with this electronic evidence. There are two other deeming provisions in BSA. The one is joint trial, deemed joint trial. Deemed joint trial, which was there in the old Section 30. Section 30. Now it is a Section 24 BSA, deemed joint trial, fiction created. Then another one is the old Section 119, deemed oral evidence. Evidence of a deaf and dumb person given in writing. That's a deemed oral evidence, though it is given in writing. So now there are three deeming provisions in the BSA. There were only two in the Indian Evidence Act. So now we shall discuss Section 63, the remaining part of Section 63. In Section 63, some modifications have been made. The first one, we have seen that the word create is used. The word create is used. The word create was not there in Section 65B. The another one is computer and communication device. So communication device. it is an expression that is inserted in section 63, modification. Then another modification made in section 63 is with regard to the certificates. So certificate we shall see now. Conditions mentioned in subsection 1. We can find the first set of conditions in subsection 2. Subsection 2. The conditions referred to in subsection in respect to a computer output shall be the following, namely, the computer output containing the information was produced by the computer or communication device during the period over which the computer or communication device was used regularly. So there was a regular use of the computer. It was not used for a particular instance, on a particular occasion. It was regularly used one. And it was used to create, to store, or to process information for the purpose of activity, any activity regularly carried on over the period of the present person having lawful control over the use of the computer or the communication device. It's very difficult to remember these things. But must remember that there was a regular activity carried on, just like a commercial establishments. In a bank, there was a regular activity going on, and it was regularly used over a particular period. And the person it was used by the person having lawful control. So the person should have, the person who used it had lawful control. There was regular activity, and it was used regularly to record or storage. These are the conditions in subsection 2, clause A. Now, subsection clause B. During that said period, information of the kind contained in electronic record or of a kind from which the information so contained is derived was regularly fetched into the computer or the communication device in the ordinary course of the said activities. It was not an exceptional occasion. It was ordinarily done. In the course of the ordinary activities, it was done. That is the second requirement. The third, clause C. Throughout the material part of the said period, the computer communication was operating properly. So there was proper functioning of the computer. Clause C relates to the proper functioning. There was no breakdown, nothing like that. It did not go out of operation. That clause D. Information contained in the electronic record is reproduced or is derived from such information fed into the computer. That means the computer output you have produced was produced from this original computer. That is from, I have told you that it is a computer output. That means it should come out of computer. That computer had the original in it, had the original electronic record in it. The computer output has come out of the original electronic records. These are the clauses in subsection 2 of section 63. These conditions are related to use of computers. Subsection 3. Subsection 3 only says what type of computers are there. Where over any period, the function of creating, storing, or processing, the three purposes: creating, storing, processing information for the purpose of any activity regularly carried on over that period is mentioned in clause of subsection 2 was regularly performed. So there are regular performance of it. Communication device. Then, what type of computers? 1. Standalone mode. Everyone knows, a single computer. Then, on a computer system, several computers are used in the same process, especially in commercial establishments. A computer network, LAN and WAN, and a computer resource defined in Information Technology Act. All these terms, or through an intermediary. All these are considered a computer. And computer network, one computer only. Computer system, considered one computer. Standalone, one computer. Intermediary, one computer. So all these are different types of computers for the purpose of section 63. There is some changes have been made in this particular types of computers. Section 65B was a different one, but now ABCD is a different one. That is sufficient for our purpose so far as subsection 3 is concerned. But subsection 4 is very important. Subsection 4 is very important. Subsection 4 is just like section 65B4 of the Indian Evidence Act. But several changes have been made. Several insertions have been made. Several modifications have been made, which are of much significance. So let us first read. In any proceeding where it is desired to give a statement in evidence by virtue of this section, that means you have to give a computer output, a copy of a secondary, a copy of a electronic code as evidence in case you desire to give it. Then there should be a certificate. So section 65, section 63(4) mentions the requirement of a certificate to admit that secondary evidence in evidence. So it should be, there should be a certificate, and that certificate should contain what? Doing any of the following things shall be submitted along with the electronic record at each instance where it is being submitted for admission. It's very difficult to analyze it. We shall analyze first thing. So it simply says that there should be a certificate, and that certificate should contain the following facts and any of the following things. Then several things are mentioned. After saying any of the following things, several facts are mentioned, A, B, C. So what does it mean? It means any means what? Anyone. Any one of you means any one of you. One man, not all. Any means one, not all. If that is true, if the expression used here is true, right, that means any of the following three conditions, A, B, C, that is sufficient. But that is not actually meant by this provision. The Supreme Court in Arjun Pandit Rao's case, 2020, Volume 7, SEC 1, held that the word any should be read as all. So it should be read as a certificate doing all of the following things shall be submitted. All of the following facts. Here, identifying the electronic record containing the statement and describing the manner in which it was produced. So you should identify the computer device. Then you should give particulars of the device involved in the production of the electronic record. Particulars of the computer. Then see, dealing with any of the matters contained in subsection 2, we have seen that A, B, C, D, 4 clauses are there. Here again the word used is any. It should be read as all. So the word any in subsection 4 should be read as all. That is what the Supreme Court has held in Arjun Pandit Rao's case. So it is a mistake there. And who should give the certificate? So there should be a certificate containing the following facts, A, B, C. But who should give that certificate? Further, the section says, it should be signed by a person, purporting to be signed by a person. It should appear that it is signed by a person. It should be signed by a person under the Indian Evidence Act, section 65B41. Who should have signed it? Who should have signed it? A responsible officer or a person in management of the activities. That has been changed now. Now it says that signed by a person in charge of the computer or communication device. It is sufficient that it is signed by a person who was in charge of the computer or communication device or the management of the relevant activities. So suppose in a bank, a clerk is in charge of the computer. Going by the act, by this provision, it is sufficient that he gives a certificate. He need not be a manager. He need not be a manager. It is sufficient that it is signed by the person who was in charge of the computer, any person. But under the old act, it was sufficient that certificate was given by one person. But under the BSA, further something more is there. That is, and an expert. So at present, under section 63(4), a certificate of an electronic record, secondary evidence of an electronic record, should be issued by two persons. One, by the person in charge of the computer or communication device, or a person in management of the activities of the institution. The second, by an expert. What does it mean? Ordinarily, it is not possible for a litigant to get a certificate. He should get it from the person who was in charge of it. The second, it should be signed by an expert. Who is an expert? Where will you go to seeking this expert? Who will give you a certificate? There are practical difficulties. When we come to section 63(4), there are practical difficulties, and it is very difficult to comply with this provision. And there are some other problems also. See, so the certificate should be given by the person in charge of the computer or communication device, or a person in management, as well as an expert. As well as an expert. Here, remember, a format of this certificate is given at the foot of this document, this BSA. So, unlike the Indian Evidence Act, BSA contains a schedule at the foot of that act. BSA has a schedule at the end of this, at the foot of this act. And this section says, in the certificate specified in the schedule. So there is a certificate specified in the schedule seen at the foot of this BSA. Now let us look at this schedule. The schedule, certificate, under section 63(4). C is actually section 63(4)(c) need not have mentioned. Section 60. It is not actually C, but it is section 63(4) only. Yes. There are two parts. Part A, Part B. Part B, first we shall consider. That is to be filled by an expert. So the form of certificate to be issued by an expert under section 63(4) is contained in Part B. Okay, there is no problem. An expert will give it in that form. But when we come to Part A, there are problems. See, who should give it? I don't know whether you have this schedule before you. If it is before you, you see what is written just below Part A, to be filled by the party. So who should fill that form? Section 63(4) says it should be given by a person in charge of the computer. But section Part A of the schedule says it should be filled by the party. Filled means by the party means certificate given by the party, which is evident from the next two sentences. I have produced the electronic record or output of the digital record taken from the following device. So who gives the certificate? I have produced means the party. The party. Again, coming to the end of this section, I state that the hash value of the electronic record is dash obtained through the following algorithm. So what is meant is that the certificate for Part A of the certificate should be given by the party. But what is stated in this section? The certificate is to be given by the person in charge of the computer management. So there is a conflict between the provision and the form that is attached. But the section says that it should be in the form specified in the schedule. How can you comply with it? You cannot comply with it. Then, what are the facts to be stated in the certificate? Suppose you are ready to issue a certificate. What are the facts to be stated? See, I state that the hash value of the electronic or digital record is dash. Can any one of you say the hash value of an electronic record? Can anyone? I think no one can say it. Then, through the following algorithm, that is the SHA1, SHA256, MD5, other one, hash report to be enclosed with the certificate. Who has to issue this hash certificate? There is no mention. Who has to give the hash certificate? So, in fact, it is impossible to comply with the requirements of section if the schedule is considered a part of the section. Moreover, we can see section 61. So we shall consider later. So that is with regard to the nature of the certificate. Now, what are to be stated? Further stated in the certificate. And for the purpose of this subsection, it shall be sufficient for a matter to be stated to the best of the knowledge and belief of the person certifying it. So after issuing the certificate, it is sufficient for the person who certifies to say that this is true to the best of my knowledge and belief. Do you know whether the Supreme Court has stated anything about this phrase, to the best of my knowledge and belief? Ordinarily, we see it in affidavits presented through advocates or prepared through advocates. What is stated in paragraph 1, 2, etc., true to the best of my knowledge and belief. Take a case, it is a divorce case. Husband and wife. They have a son, age 21 years. And in the first paragraph, they say, we are husband and wife. And in the second paragraph, the other party is our son. And at last they say, what is stated in paragraphs 1 and 2 are true to the best of my knowledge and belief. Does it not look awkward or senseless? If you believe a thing, that means you have no knowledge. If you have knowledge, that means you need not believe it. The two expressions do not convey the same thing. If the mother knows that he is the child, then why should he say that it is the best of my knowledge and belief? It is not her belief. It is her knowledge that this was the son born to her. Father, it may be a belief. It may be a belief. But at least to the mother, it's not a belief, but it's knowledge. So the Supreme Court said that in a certificate given under section 63(4), that is 65(b)(4) first. You need not give a certificate like that. It is sufficient. It is true to the best of my knowledge, sufficient, or it is the best of my belief. Either will do. That is what the Supreme Court has said in Arjun Pandit Rao's case, 2020, volume 7, SEC 1. Okay. Now we come to the other part, which is seen in the first part of subsection 4. That is, at what stage the document should be produced. So the certificate should be produced. At what stage? This was also considered by the Supreme Court in Arjun Pandit Rao's case. The section now says, it shall be submitted along with the electronic record, where it is being submitted for admission. So what is the stage at which the certificate the party should produce the certificate? It is when it is submitted for admission. When do you submit a document for admission? When you tender it in evidence. So it is sufficient that there is a certificate when you tender the document in evidence and not when you produce it before the court. It need not be there when you produce it. So when you produce it, there may not be any document, there may not be a certificate, because it may be difficult for you to get a certificate. So what you have to do? This was considered by the Supreme Court in Arjun Pandit Rao's case. And the Arjun Pandit Rao's case, Supreme Court said that you need not produce it along with the document, but you must get it before the document is tendered in evidence. Then the question arose for consideration was, how can you get a certificate? The Supreme Court has answered it. There are several ways of getting a certificate. You can apply through court for a direction. You can apply through court for a direction. And in this connection, you may remember that there is a provision in the CRPC, section 91. The present section is 96, I think, which says that the court may order a party to produce a document at any stage of the proceedings, investigation, inquiry, or trial. So you may apply under section 91. The party who wants a certificate, a certified copy should apply under section 91 CRPC and 96 BNSS, so that you may submit it when it is tendered in evidence. In civil cases, in Order 16, Rule 6, you may apply for a certificate, for a copy. Direction by the court to issue a copy. Then, again, Section 165 Evidence Act, corresponding to Section 168 BSA, the court can order production of a document. The court can order production of document, suo motu also. And suppose the party who has to give the certificate does not produce it, what is the remedy? What is the remedy? In criminal case, the remedy is in Section 3. First one is the court can issue a search warrant under Section 94. The court can issue a search warrant. But since this is a certified copy, there is no use in issuing a search warrant, but they have to prepare it. But there is a provision in CRPC itself. That is Section 349. Arrest and send him to prison. So if the party who is ordered to give a certified copy of a document does not produce it in court, the court can, criminal court can invoke Section 349 and send him to jail. And in criminal case, civil cases, Order 16 or Rule 10 CPC, you can attach his property, you can arrest him and send him, detain him. So that means at any stage before the tendering of the evidence, it may be obtained. You need not produce it along with the document itself. But it should be there when it is tendered in evidence. That is sufficient. Then, and it should be submitted at each instance. That does not appear to be a logical one, unless what is contemplated is a separate certificate. So if the certificate is an independent one, and you produce that record again in another case or another court, you have to produce that certificate also. That means another instance. That is the only meaning we can give to this at each instance seen in Section 63(4). So I think we have discussed the subsection 4 sufficiently for our purpose. Now subsection 5. For the purpose of this section, information shall be supplied to a computer or device, communication. If it is supplied there to in an appropriate form, whether it is supplied directly, is of no significance. It can be produced by a computer, communication, whether it was produced, etc. It's not here. There is some modification in it. That is, or by other electronic means, etc. Now we shall see. there is another provision regarding electronic evidence in the PSA, which is not often noticed by investigating officers and advocates. That provision is Section 90. Section 90. Presumption as to electronic messages. There is a presumption as to an electronic message. So when an electronic message is produced in court, the presumption is that what was actually fed into the computer was the one that was received. That means in between, there was no change. The matter that was supplied, the information that was supplied to the fed into the computer was the one that was received. What was given to the computer was the one that was given by the computer. Given to the computer was the one that was given by the computer, product of the computer. There is no change, but there is no presumption. That is important. There is no presumption as to the person who sent it. But often, what happens is that these investigating officers produce computers of accused, used by the computer by the accused, and they said that this mail was sent from this computer, so he is guilty. That's not sufficient, because there is no provision, there is no presumption that though it was sent from his computer, it was sent by him. Take a case while I was taking a class. Another person was using my mobile phone, and he sends a mail to another person. It was sent by mobile phone, from my mobile phone. There is no presumption that I sent it, because it can be used by anyone. So that is the presumption contained in Section 90, presumption as to electronic messages. Electronic messages. Now, you know that when there are two aspects with regard to admission of a document, one is relevancy and the other is admissibility. Admissibility is contained in the first part of Evidence Act or the BSA, and admissibility in the second part. Admissibility is nothing but mode of proof. So we have seen that a primary evidence can be adduced as evidence or a secondary evidence. To produce a secondary evidence, you have to comply with certain conditions. Unless these conditions are satisfied, it is not admissible. The question here is whether that can be waived. The mode of proof can be waived. In an ordinary case of documents, the mode of proof can be waived. The question here is, in the case of electronic records, an electronic record did not contain a certificate, but it was not objected to. It was not objected to. Can it be admitted in evidence, whether this admission is right or not? Yes. Supreme Court in one case said that it can be waived. I think there is no change because it is only a mode of proof. Section 63(4) only says a mode of proof. So AER 2017 Supreme Court. AER 2017 Supreme Court. 3441. Sonu versus State of Haryana. AER 2017 Supreme Court 3441. The right to object can be waived. If it is not invoked, that right is not exercised, that is the end of it. So another question is, what is the effect of producing a certified copy? That is Section 63(4) certified copy. What is the effect of production of such a copy? it only means that it is as good as production of an original. No better effect is there. The effect of production of a certified copy of an electronic record, it is as good as production of the original. You can see it in section 63(1). With the or shall be admissible in any proceeding without further proof or the production of the original. So it only dispenses with the production of the original. The effect is given in section 63(4) also. It shall be evidence of any matter stated in the certificate. And for the purpose of this section, it shall be sufficient for a matter to be stated, etc. So it only means that it takes the place of the original. If the genuineness of the original is to be proved, you have to adduce further evidence. That's all. It does not guarantee the truth of the statement contained in the electronic record. Then, vexatious question arises as to the issuance of copy of electronic records. One such case came up before the Supreme Court. That is, how to give a copy of an electronic record from a court. Because after getting the copy, he can make alterations in it. How can you certify it? Suppose it is a CD. You cannot write on it that this is a certified copy, because its contents can be changed anytime. So the Supreme Court said that you give a cloned copy subject to certain conditions. How to give a copy? AR 2017 Supreme Court 1136. You give a cloned copy and the party has to give a certificate affidavit that he will not challenge its correctness. I think with that we can wind up the discussion. There are some provisions like electronic signature, presumption, etc. Some documents. Then wherever you see the word document, electronic records also has been inserted. Section 93, old section 98, presumption as to electronic record 5 years old, but with regard to a document it was 30 years old. Ordinary document, admission document is 30-year-old document, but electronic record, it is a 5-year-old document record. Section 93. Section 93. And there are some provisions mentioning electronic records. They are not of much significance. So I think we have done an exhaustive study of electronic evidence. No provision I have left out. I think I have covered almost all the provisions. Remember that no authoritative pronouncement has been given by the Supreme Court so far as certain aspects are concerned. We have to wait for it. Especially section 63, I have shown that there are inconsistencies and it's difficult to prove an electronic record on the basis of the provisions contained in section 63(4), because there are conflicts between the provision and the form and a requirement of 2 persons certifying it. And in almost all cases in future, civil or criminal cases, there will be electronic records. And that means that will delay the trial of the cases till the Supreme Court gives an authoritative pronouncement on this aspect. So thank you very much. If you have any doubt, send it to these organizers and they will send it to me and I will try to answer those questions. Though I do not claim that I have thorough knowledge in electronic evidence, because as I told you at the beginning, I belong to the old generation, but you belong to the young generation. You understand this technical aspects very easily. Okay. So thank you very much.
Thank you so much, sir, for the enlightening session. Your deep insights into the concept of electronic evidence have provided immense clarity on the topic. It has been an absolute privilege to learn from you. On behalf of LiveLaw Academy and all the viewers, I extend a heartfelt gratitude to you, sir, for taking out the time and sharing your expertise today with us. As we conclude, I would also like to inform all the viewers that the complete details of our upcoming Judicial Services Preparation course will be shared soon. Thank you all for joining us today. Have a great evening ahead. Thank you so much, sir. It was a privilege and it has been so exhaustive. It was just an amazing session. Thank you so much, sir.
I have been honored by the request extended to me by the LiveLaw. So thank you. Good night.
Good night, sir. Thank you.
All the best.
Thank you.